Good evening, everyone. Welcome to Safeguard Your Legacy, Protecting Your Home After Death. This is the presentation by the Queens Coalition, Protect Your Home Coalition, and we would like to thank Senator Leroy Comrie for being the sponsor of tonight's workshop. My name is Lori Miller. I'm the Executive Director of Neighborhood Housing Services of Jamaica. And as I said earlier, tonight's presentation is actually a two-parter. Part one is tonight. Part two is going to be next week on the 14th. And the topic is Safeguard Your Legacy, Protecting Your Home After Death. So the coalition is a group of organizations, nonprofit housing organizations, as well as nonprofit legal services organizations. And we came together a few years ago when we were funded by the New York State Attorney General's office. And the goal of the Protect Our Homes initiative was to focus on prevention enforcement, because we started to see a lot more scams and deed theft and other things that were putting our homeowners in southeastern Queens at risk. So again, it's a network of community partners. It was the New York State Attorney General's office, New York City's Housing Preservation and Development Department, HPD, as they're commonly referred to. And the goal was to reach out to the community to educate folks about the options that they had to try and protect their properties, to make people aware of the various scams, and most importantly, to let people know that there are organizations out there like ours that are funded by the government to help them, should they find themselves at risk. As I said, the anti-displacement efforts were for neighborhoods that were seeing high incidents of scam and deed theft. So it was Central Brooklyn, Southeastern Queens, and the North Bronx. Law enforcement agencies were involved, if and when we found there were cases of, fraud and deed theft. And so we got together and we decided that it was important for us to work together. So Neighborhood Housing Services of Jamaica, Brooklyn Legal Services Corporation A, the Legal Aid Society of Queens, it was Jamaica branch at the time, and JASA, Legal Services for Elder Justice. NHS of Jamaica is the nonprofit housing organization. The other agencies clearly are legal services providers. So just a quick overview of Neighborhood Housing Services of Jamaica. We're a HUD certified housing counseling agency. Our counselors are trained and certified by HUD to provide a broad range of home ownership counseling services. We assist in general with finding and maintaining quality and affordable housing. We've got first-time homebuyer counseling and group workshops. The group workshops are offered every month. We have or facilitate financing, affordable financing for home improvement. Those are rehab loans and grants. And one of our programs, which is funded by the Affordable Housing Corporation, also incorporates construction services monitoring by, a licensed contractor and professional who works for NHS. We also provide foreclosure prevention counseling for homeowners who find themselves at risk, we'll say at risk of foreclosure. Quite often they're not quite there, but they may be falling behind on their mortgages, and we'll work with them to help apply for mods, et cetera. We also work with homeowners and tenants on the various tax exemptions that are offered by the city. Folks who find themselves behind on their property taxes or water sewer charges, or maybe who had emergency repairs that were done by the city and then charged to the homeowners, those folks can come to NHS and we can help them apply for repayment plans so they can avoid more issues further down the line. We are a housing ambassador for housing for HPD, which means that we can help individuals who are looking for affordable housing and applying to the lotteries. They can come to us if they have challenges applying on their own to apply for these lotteries. And then we do financial wellness, usually referred to as financial literacy education. And those modules include topics like budgeting, credit, insurance, estate planning. It's sort of a full service agency. So that we deal with renters, we deal with homeowners. The next partner in the coalition is JASA, Legal Services for Elder Justice. And I'd like to introduce Dion Woodburn, who's the Legal Services Supervisor with JASA.
Hi, good evening, everyone. The first thing I want to do is I noticed that Melissa put in the hub, will the recording be shared after the presentation? Now, Melissa, if we look amazing and we make no mistakes or anything, then maybe we'll share the recording. If not, you'll definitely get the materials, okay? So I'm with JASA Legal Services for Elder Justice. Sometimes we call ourselves the Justice League. Basically, what we do is we provide services for those 60 and older, and what our objective is really to keep our older adults in their homes and in the community, right? Some of the legal services that we provide are relating to tenants' rights, foreclosure, predatory lending, prevention, real property fault. We do scams, elder abuse, prevention, financial exploitation prevention, consumer and utility law, health and long-term care. And then, of course, we do entitlements to government benefits. And right now, everybody's thinking about those tax liens and things like that. We provide information on that with tax deductions and tax credits.
Thank you, Dion. Next up is Casey Lee, who's a staff attorney with Legal Aid Society of Queens, and she works in the foreclosure prevention and home equity preservation unit. Casey.
Good evening, everyone. So Legal Aid Society provides similar services as all of our partners. And so we do have a housing unit that does work specifically with tenants to prevent eviction and displacement. As Lori mentioned, I'm part of our foreclosure unit, which covers a broader set of homeowner issues. I'm one of one. I'm the only attorney at Legal Aid who does estates work specifically. And I work primarily with our foreclosure unit attorneys and trying to keep people housed, particularly heirs. I'll pass it off to Emily.
And so Emily is a paralegal in the Consumer and Economic Advocacy Program with Legal Aid. Oh, I'm sorry, with Brooklyn Legal Services Corporation A. So she's going to tell you a little bit about BKA, and then she'll go right into her presentation, which is dealing with property taxes and the Department of Finance.
Yes, thank you so much, Lori, and good evening, everyone. Thank you for joining us. As Lori mentioned, I'm a paralegal at Brooklyn Legal Services Corporation A, and we similarly provide several services to homeowners as well as renters and small business owners who are dealing with several different kinds of legal challenges. We provide representation and advocacy, including full representation, brief advice, outreach, and education to low and moderate income individuals and families, community-based organizations, community development corporations, coalitions, and small business owners throughout the city. And we provide advocacy that protects housing for everyday New Yorkers, as well as access to education and healthcare, and safeguards subsistence income for our city's most valuable residents. We also represent homeowners facing foreclosure, and we defend homeowners against predatory lending, and represent taxpayers who have issues through the Low Income Tax Clinic. And with that, I will get started with what I will be presenting today, which is about the upcoming tax lien sale, which is taking place on May 20th in less than 2 weeks. So what is a tax lien sale? If you owe New York City property taxes, charges, or water and sewer bills over a certain amount, the city may sell your debt to a private company through what is called a lien sale. And as I mentioned earlier, this is coming up in less than 2 weeks on May 20th of this year. So once your debt is sold, the company that buys the debt can add high fees and interest on top of what you already owe. And ultimately, this makes you far more likely of having your home foreclosed on. So this is a very serious kind of threat to your property in the event that you're on the lien sale and you stay on the lien sale and your debt is purchased by a private company that adds those charges. So we really want to avoid this at all costs. So your home may be in the New York City lien sale if you owe property taxes, water or sewer charges, including surcharges, if you owe emergency repair and alternative enforcement charges, or if you owe interest, fines, or fees on the taxes and charges above that I just listed out. If you are an owner in a delinquent payment plan and have not made payments for 6 months, your property might be in the upcoming tax lien sale. And lastly, if you have a Housing Development Fund Corporation, also known as an HDFC, rental property with $5,000 of unpaid charges for over 2 years, you may also be in the upcoming tax lien sale. So to find out whether your home is in the lien sale, there are a few different steps you can take. First and foremost, the New York City Department of Finance is required to mail you a lien sale notice 90, 60, 30, and 10 days before the lien sale date, which again is May 20th of this year. So more likely than not, you should have received a notice in the mail or several notices likely regarding your property being in the upcoming tax lien sale. If you've not received these notices, we still highly recommend that you check the online page, which has a comprehensive list of the properties in the upcoming lien sale. You can either visit this website, which, as Lori mentioned, we'll be sharing this deck afterwards. So you can click on this website, or alternatively, you can Google NYC lien sale, and you will be taken directly to the page with the comprehensive list of properties in the upcoming sale. Lastly, if these resources are not accessible to you, you can definitely call the New York City Department of Finance at this number to ask them whether your property is on the upcoming lien sale. And so, how can you get your home off of the lien sale? I'll be walking us through 4 different methods and approaches that will allow you to access different exemptions from the upcoming lien sale, including entering into a payment plan, applying for property tax exemptions, submitting a lien sale easy exit program application, and then submitting an emergency repair certification. And I apologize for the typo on those numbers there. So first, I'm going to talk about entering into a payment plan. You may be eligible for a PTA, which is also known as a property tax and interest deferral payment plan, if you adhere to these following, or if you meet these following 4 criteria. First, if you own a 1, 2, or 3 family home or condominium unit, and if the property has been your primary residence for over a year, and if your income for all homeowners is $107,300 or less per year, and if you have fallen behind or are in danger of falling behind on your property taxes, you can enter into one of these PTA'd payment plans to begin paying off the debts or arrears that you owe. And you may also be eligible for a PTA'd circuit breaker plan, which is similar to the PTA'd plan that I just went over if you meet the previous criteria that I shared in addition to these new criteria, which are that your property tax bill is more than 10% of your income, or if your property's assessed value is $250,000 or less, you can be eligible for the circuit breaker plan. And it's important to note as well that these payment plans typically have, they do have interest, but the rates are variable. So if you're able to enter into a payment plan, this is absolutely one option to get your property off of the upcoming lien sale. So second, I'll be talking about applying for property tax exemptions, and there are 3 exemptions in particular that I will be going over. It is important to note that on the forms for these 3 programs, it does say that the deadline passed in March. However, you can still apply and submit applications for these 3 programs to be eligible for an exemption from the upcoming lien sale. However, it's important to know that what the deadline is referring to is the actual taxpayer benefit that you will receive. That portion of the application, or of the benefit rather, will not go into effect until next year. In other words, you can get off the lien sale by completing the application and getting it approved, but you will not get the actual tax benefit until next year. So we'll go over the senior citizen homeowners exemption, the disabled homeowners exemption, and the veterans exemption briefly in the next slide. So beginning with the senior citizen homeowners exemption, I'll just quickly share eligibility criteria for each. And again, all of this information can be found online. If you look up NYC lien sale, you'll find each of these exemptions with the forms needed to complete. So you might be eligible for the SCHE senior citizen homeowners exemption if all owners of the property are above 65 years of age or older. And you might qualify for the disabled homeowners exemption, or DHE, if all owners are people with disabilities. And lastly, they do have a veterans exemption, and we recommend viewing the website for eligibility requirements, seeing as they're a little bit more complex than the previous 2 exemptions. And it's important to note that for each of these different exemptions, to get off the lien sale, you must have a combined annual income among all of the owners of $58,399 or less, and the property must be the primary residence of all owners. So keep that in mind as you're considering whether you might qualify for these exemptions. second to last, I'll be talking about the Lien Sale Easy Exit Program application, which is one of the more common applications we've seen at Brooklyn A. And for the Easy Exit Program, you might be eligible if you own a 1, 2, or 3 family home or condo unit. If the property has been your primary residence for the past 12 months. If you do not own any properties in New York City, so you cannot own any other properties in order to qualify for this program, for this exemption, and the combined annual income of all owners must be no greater than $107,300. So these are the eligibility criteria. And just note here as well that LLCs and corporations are not eligible for this program, unfortunately. However, there was a recent policy change that went into effect last week, which states that trusts and properties held in trusts are eligible for this program. Although this is a recent development, we do recommend that you apply if you have a property on the list that is held in a trust. And on this slide, I'll just briefly go through the steps needed to complete the Easy Exit Program application. First, you must request a link to the application, which will be sent to your email 2 to 3 minutes from the request. And be sure to check your spam email. There are also paper applications available online, but we do highly recommend doing the electronic application if that is something that's accessible to you. Second, you must complete the application, including getting the required documents, which includes tax returns if you have them. And if you do not have tax returns, you must include all proof of all income. So, Social Security benefits, etc. Those must be included as documentation. And then additionally, if there are medical concerns or chronic issues, that the applicant has been dealing with, they can provide medical documentation of that as well. And you will receive a confirmation email once you submit, and you'll receive a decision within 30 days, although we've been seeing far faster turnaround times for applications submitted virtually online. So lastly, you can get out of the upcoming lien sale by submitting an emergency repair certification. If you owe housing prevention and development emergency repair charges, you might be eligible for this exemption if the property is a 1, 2, or 3 family residential property in tax class 1, and if you are the owner of the property and it is your primary residence. It's important to note that for the Easy Exit application and for this application, both of these exemptions remove your property for the lien sale for 1 year. And that is essentially, the benefit that you will receive if your applications are approved. So moving forward, I just briefly want to touch on the deadline for submitting these exemptions. I really cannot stress enough how important it is to submit these applications as soon as possible if you think you might qualify. The deadline is approaching in less than 2 weeks, and we want to be sure that we can try to get your properties off of the upcoming lien sale list. So, applications will be accepted through May 19th at midnight, but again, we really highly encourage, we cannot stress enough how important it is to apply as soon as possible. All applications require some form of documentation, whether it be income, tax returns, deeds, etc., and these can take time to gather. So please err on the side of caution and start your applications as soon as possible. And lastly, as I mentioned earlier, please consider applying online as it's far faster and more efficient than applying through submitting paper copies, although that is an option. And the last quick thing I'll mention on the lien sale list is that you can submit an appeal to any denials that might be made of your application. So those appeals must be submitted within 10 days of receiving your denial. And additionally, you can absolutely reach out to any of the legal service providers on this call if you would like advice or need further information about the options available to you if your property is on the upcoming lien sale list. So please feel free to reach out if you have any questions. And now I will pass it over to Casey Lee.
Hi, everyone, again, and good evening. Thank you so much for joining us. So I'm here to talk about protecting your home after death. This slide right here, it seems very simple, but I'm actually going to spend a good amount of time here because understanding what type of ownership you have will pigeonhole you in terms of what will happen after you pass. And so the first one here we have is fee simple, which is our most simple form of ownership. This is where an owner has complete and absolute rights to the property, which means they can use it, sell it, transfer it indefinitely. The second form of ownership that we have is tenancy in common. This is a form of co-ownership where two or more individuals hold title. There are no rights of survivorship, which means that if an owner is to pass, their share passes to their heirs if they don't have a will, which is according to the laws of intestacy, or as specified in their will. Tenants in common can have equal or unequal ownership shares. So this is where you might have someone who owns 99% and another who owns 1% because you need that person with 1% to get a mortgage to purchase the home. And regardless of the percentage of ownership, each owner has a right to use and occupy the entire property. And so how do you get this form of ownership? You might have like you and your sibling, someone not your spouse purchasing the home, or you might inherit the home, and that's how you form a tenancy in common. It's important to note that this is also the default form of ownership. So if you have two owners who are not married, and the deed is otherwise silent, they are tenants in common. The third form of ownership we have here is tenancy by the entirety. So this is a type of co-ownership, again, that is available only to married couples. It protects the property from claims against the spouse's individual debts. There is a right of survivorship, which means that, if the husband were to pass first, the wife, without lifting a finger, automatically assumes ownership of the entire home. Another form of protection is that neither spouse can transfer their interest without the consent of the other spouse. The fourth form of ownership we have here is a joint tenancy with a right of survivorship. Another form of co-ownership where two or more people have equal ownership. So no 99 and 1%. This is equal. There are rights of survivorship as indicated in the title. And so that means that there is no need for going to surrogate's court when one of the owners passes away. We see this sometimes, and I want to caution, this is a note of caution. I get a lot of clients calling to add someone to the deed. This can be risky. And so a lot of times you'll have like a parent and a child. If that's how you take ownership of the home, that's totally fine. But if you're adding someone, one risk is that that person could lose what's called the step up in basis. So what is this? We can spend an hour talking about it, but the very, very simple version of it is, let's say you have a homeowner, a parent who buys the home back in like 1950 for $100,000. That home is now worth $1 million. By adding your child to the deed, the child can no longer sell the property, or is now going to have to pay the tax or whatever, the estate taxes. This is not my true area of specialty, but they'll have to pay for the increase in value from 1950 through the present. Whereas if they just inherited the home today, they would benefit from the step up in basis, and they would only be responsible for the additional value going forward from today forward. The other risk with adding someone to the deed with a joint tenant with rights of survivorship is that this new owner can go ahead and encumber the property, or their debts can attach to the property now. The fifth form that we have here is a life estate. So again, another form of co-ownership, but instead of having a different percentage of ownership, it's the ownership is divided in time. So you have a current owner, the life tenant, who has a right to use and occupy the property during their lifetime, while this other person or persons or remaindermen have a right to use and occupy the property after the life tenant dies. This is similar to some of the like tenancy by the entirety or joint tenants with rights of survivorship, because you can also avoid probate. We see this oftentimes when in like emergency Medicaid planning. But another note of caution, this is not like the best form of ownership out there. The life tenant and the remainderman, even though they get to use and enjoy the property at different times, they both have a present interest in the property. And so that means that if the life tenant, the current owner, needs to do repairs on the home, needs to get a new roof, and needs a loan to do this, they need consent from the remainderman to attach to encumber the property. This also means that the remainderman could go ahead and sell their interest today. because they already have this right to do so. The last one, co-ops and condos. So they seem similar, but they could not be more different. A condo is like a home with a homeowners association. A co-op looks and smells like a condo, but it is not real property. A co-op is technically personal property. The ownership is in shares of a corporation that then leases your apartment to you. And so right off the bat, there is this distinction between ownership of the shares and a right to reside or occupy in the apartment, a right to reside or occupy the apartment. And so with a co-op, for the ownership, your name would appear on the stock certificate, and then who gets to live in the apartment is determined by the proprietary lease. And so when a shareholder dies, this is a two-step process. Ownership has to go through surrogates court, except in the very, very rare circumstances where somehow the board allowed ownership to go into a trust. And then even once you pass that hurdle, then you would still have to get board approval to reside in the apartment. So I think talking about these ownership structures really shows you the importance of estate planning. And so we need to plan ahead, especially if there are minor children, especially for non-traditional families. And, you know, a lot of this is a very frank conversation with your family members, and that will help so much with avoiding some of the squabbles that can happen after death. And so in this next section, we're going to talk about surrogates court. We're going to talk about intestacy versus, which is the state's plan when you pass away, versus having your own plan in a last will and testament, and some estate administration and planning by deed. And so surrogates court. So surrogates court is a court of special jurisdiction that handles estates. Each New York City county has its own surrogates court. And this can be a very expensive and long process. Court fees are determined by the size of the estate. And so if you have a home in New York City, if your estate is worth $500,000, and this is regardless of if it is mortgaged, $500,000 means your court fee is $1,250. The process for petitioning can be months to years, depending on the complexity. And surrogates court may require a bond or place restrictions on any transfers. And this is especially true in an administration proceeding, which is where the person passes away without a will. And so this is just an extra expense on the people that you're leaving behind. And why do we have to go through all of this process? Well, it's because third parties may require letters of administration. So if you are an heir and you find yourself in a foreclosure process, the bank may require you to show proof that you are the administrator and that you've notified all of the heirs. So the mechanics of petitioning in surrogates court. It's a lot of work. It's a lot of legwork. You have to collect the names of all the names and addresses of potential heirs. This is with a will or without a will. All of the heirs. You have to collect their information. You have to obtain a death certificate. I always recommend getting multiple original death certificates. And then you have to file a petition with the clerk. You have to serve notice and waiver of consent or waiver of citation on all of the interested and necessary parties. So up with that, collecting names and addresses of potential heirs, you're going to have to notify everyone. And that's, again, with a will, that you have to notify, you know, that brother that disappeared down out of state. And if you can't find these people, then you will likely have to do what's called notice by publication, which can be very costly in New York City. It means you're putting an ad in the newspaper or however the surrogate wants you to do it. And then once you go through all of this process, you can obtain a surrogate's court order. And so when someone passes away without a will, that would be letters of administration. If they pass away with a will, then it's letters testamentary. An accounting is not mandatory in New York, but I will caution you. I've had at least one client call me saying that the surrogate was requiring an accounting in order for that person to be released from the bond. So this is a process. Intestacy, what happens when there's no will? I like to ask people up front, do you have a plan? And the people that say they don't have a plan, well, they do have a plan. They've chosen the state's plan. And so the state has a plan for how things go when you don't have a will, and it tends to favor traditional families. So a person's estate will first go to their spouse and their children, and children is biological and adopted. Then if those don't exist, then it goes up to parents, then down to siblings, and then more distant relatives. I do want to point out a little bit. If you do look online, traditionally people say the first $50,000 of an estate goes to a spouse, and then the remainder is split between a spouse and their children. But there is a provision that where there is a surviving spouse or a child under 21, the first $25,000 passes completely outside of this. This is not part of the estate, which means this wouldn't count towards that fee that I just mentioned earlier. So 25,000, and that could be either the person's bank account or if they have personal assets. So like, let's say in their home, they have jewelry, that counts first. And so you take that outside and then you count the rest of the estate. And so this is important in determining whether or not surrogate's court is necessary, right? If you're renting and you have a joint bank account with a surviving spouse, you don't need to go to surrogate's court. The joint bank account passes automatically to the spouse. Let's say you own a home as joint tenants with rights of survivorship and you have a joint bank account. Again, all of those things pass automatically. You don't need to go to surrogate's court. But let's say the decedent, the person who passed away, is the last surviving title holder, or there is no designated beneficiary on a bank account, then you need surrogate's court. If you're a shareholder for a co-op, you're going to need surrogate's court. And so when there's no will, you are petitioning for letters of administration. And the person who's petitioning, once appointed, becomes the administrator. And they have a fiduciary duty, which means they have an obligation to higher than, just being a good friend. Like, no, you have to keep track of all the money that's coming in. You have to put it into an estate account, and then you have to distribute first to the creditors, and then in accordance with the statutes or however the court directs you to. What happens when for letters testamentary? The last will and testament, or just the will, identifies who the decedent wanted to be their executor and hopefully their successor executor. Importantly, a last will and testament likely dispenses with the bond requirement for the executor, which means if you do nothing else with the will, you dispense with the bond, so your executor doesn't have to deal with that. An executor, like the administrator, has a fiduciary duty to the estate and has to distribute assets in accordance with the decedent's wishes in the will. And again, fiduciary, the executor has to put the interests of the estate above their own. There is a chance in some situations where you might be able to avoid probate. So for instance, in a situation where the decedent owned a home and there's only 2 children, if they both agree they want to sell, you may not necessarily need to go through surrogate's court. It might take some time, and it depends. So, don't go crazy. And again, even when there is a will, you have to notify all the heirs. So let's say my mom passes away, she puts in her will, she wants everything to go to Casey. I still have to notify my brother. I can't just act on my own. Transferring property outside of surrogate's court. You could, as I mentioned, potentially prepare an heirship deed. I'm sorry, I sound like a lawyer. And so in this situation, you're going to need a family tree affidavit and other proof of heirship. So this is where you have to show that, Casey has a sibling, Casey's mom is this person, and dad is, that person. And you have to show the family tree and who would have inherited. And this would show that, Casey should have gotten everything and not, anyone else. In an heirship affidavit, the heirs are the grantors transferring to the grantees. So in the situation where my mom passes and my mom is the sole title holder, she wants to give everything, but she passed away without a will, sorry. My brother and I are looking to transfer the property only to me because I'm the only one here. So in that situation, my brother and I would be the heirs at law of Casey's mom to just Casey. I know that's a little confusing. In writing, it looks a little better. Or it could be to literally anyone else. So we could, deed it to one of our kids when they came of age. And in a situation where you have lots of heirs, which happens a lot, you can do partial transfers. You don't have to transfer 100%. A lot of the scammers, actually, this is how they did it, by transferring partial interest just to themselves, and now they are a stakeholder. But it's also a way to consolidate ownership. Like if you see this family tree branching out because you can't get everyone on the same page, it helps just to consolidate maybe one branch of the family into one spokesperson, really. And that can be immensely helpful. And I do want to talk about this incredible new development as of last year. It's called the transfer on death deed. I didn't bring it up before because it's not technically ownership yet. Well, okay, and you'll understand why. So this allows a title holder to designate one or more beneficiaries without having to go through surrogate's court upon their death. But until their death, they retain absolute ownership and control. They can encumber the property, they can sell the property, they can revoke this deed too. Like this is not binding, unlike a life estate. And so you still get the benefits of the step up in basis when the person passes away, or the beneficiary gets the benefit of the step up in basis. And, this is just an incredible tool that we have available to us, but I would caution you about speaking to an attorney if possible, because, for example, if one beneficiary does not survive the title holder, then the other beneficiaries take all. So if you meant to give to, your two children, one of your children dies first, but you don't have a chance to amend this deed, and you wanted it to then go to that person's grandchildren, that's not what's going to happen here. So there's a lot of things that can happen with a transfer on death deed. Overall, wonderful. But, just exercise a little bit of caution and maybe try to talk to an attorney beforehand. And so scams and predation, we've seen so much of it. This is why we all came together. We have the New York Partition of Heirs Property Act. The transfer on death deed was actually part of the amendment to it last year. And so we have some really great laws. We further criminalized a lot of the predation against homeowners, but it's not perfect. And I'm sure they will, scammers will always find loopholes, which brings us to deed theft and fraud. This is really anything where someone acquires title to your house through fraud. You really need to reach out to legal services if you think that you've been a victim of this. Other scams to be aware of, just be aware that, if you're on the lien sale list, if your home is in foreclosure, your name is on public documents. And so there are these bad actors that will search and scrape for your name. They'll reach out to you and they'll say crazy things to make you think that your problems will go away. Like if you think it's too good to be true, it is. And so in addition to pursuing any civil remedies, if you are a victim of a scam or deed theft or fraud, you can also report this to your local police precinct, and sometimes the district attorneys will prosecute these cases. And yeah, thank you so much for your time. I know we went quickly. Back to you.
Casey. So now you have the opportunity for Q&A. Deanne, I'm going to ask you to look at the chat and see if we have questions from the chat. And then if we exhaust those questions, we can then open the floor for individuals to ask their questions.
So far, we don't have any questions in the chat. except for the one about the recording.
Okay.
So everyone, please ask your questions. I mean, Casey gave a wonderful presentation, but I know there has to be questions, and everyone has to have questions on taxes. We have Emily there who knows all the answers. So come on, let's ask some questions. Lori, I'm not sure if Derek Davis would like to speak. He came in as well.
Oh, okay.
Hi, good evening, everyone. Thank you for hosting this incredible forum for our constituents and homeowners. And I apologize that the senator and I couldn't be more present. We're in the midst of listening to, and he's on the floor debating budget bills. We're finally passing a budget in the state. But again, I'd just like to thank Brooklyn Legal Services Corp. A, NHS of Jamaica, the Legal Aid Society, JASA, and the entire Protect Our Homes Queens Coalition for their continuous support for the community and for bringing this presentation to us tonight, and also the one I think we're having on the 14th. Thank you.
Derek.
Thank you. So we do have some questions. The first one is Susan and I'm going to use everyone's first name so I don't mess up the last names. And Susan is asking, what is an accounting?
So very quickly, an accounting is basically just where did the money go? Or first, what money came in? Like where was it coming from? So when someone passes away, the role of an administrator and an executor can both be called like their financial representative or the estate's financial representative. So the financial representative's job is to bring together all of the assets first. So you might have a life insurance policy if it didn't have a designated beneficiary. You might have bank accounts. You might have a brokerage account if they were so fortunate. You might have to sell assets. You might have a car, right? And you have to sell the car. All of that money or all of the now liquidated money has to go into an estate account. So the financial representative's job is to then go to a bank once they've received letters testamentary or letters of administration, open specifically an estate account and put all of the funds into there. And then once everything has been gathered, distributing to creditors. So paying funeral bills, paying credit card bills, paying any other debts first, taking a commission potentially as an administrator. So if the estate is worth more than $50,000, there are administration commissions. And that's also based on a sliding scale. I believe it's like 5% for the first $100,000. And the percentage goes less and less for each incremental amount. And so yeah, taking out the commission and then distributing to either the people in the will or the decedent's heirs. And so an accounting would be keeping track of all of this, right? So I took in $100,000. I distributed $20,000 to creditors first. And then in accordance with the laws of intestacy, I had to distribute another $50,000 to the spouse and, or probably a little more. Sorry, I'm not good at math. Don't quote me on that, but putting all of that into a spreadsheet and then submitting that to the court.
Thanks, Casey. So basically, Casey's just saying you just have to tell the court what it is that you spent from the monies, right? That's an accounting. You can't just spend the money without keeping record of it or keeping track of what you do. Like for me, I can't just go and buy shoes, right? So you have to say, I used it for the benefit of the estate, right? So then we have Sylvia, who again is asking about this recording. I don't know about this recording. It depends. It depends. It depends. And then Stacy is asking, will this link be the same for 514 part 2? Stacy, you will get notification of the next link, whether we'll be using the same one or a different link. Juanita has another question for surrogates court. Do I just walk into surrogates court to file my will? And what else do I need to bring?
Are you talking about for your own will? I haven't seen that, to be honest. Normally, the will is held either by the drafting attorney or, you know, or you could hold your own will, keep it in a safe place. It's not, some people do like to keep them in safe deposit boxes, but I will say that that is like an extra burden for your loved ones to have to get into the safe deposit box and then retrieve it and then bring it to surrogates court. So I would recommend just kind of keeping it in a safe place, letting your loved ones know this is where my will is. And so if you're asking about like what to do when you have someone's will, it's a little bit more than that. As I kind of mentioned in the mechanics section, so you're going to have the will, the filled out petition for administration or probate. You're going to need the death certificate. You're going to need money for the fee. You're going to need waivers from all of the heirs. And that's kind of a minimum. If you have special situations, like you have minor heirs, or if you have an heir who is under a disability other than being a minor, you'll need special documentation for that as well.
Thank you. And then Sandy is asking, is it okay to put my house in a trust for my kids if I have a will?
Probably. Yes, it has. A lot of people do it. Obviously, your individual situation would really depend, and I would again recommend that you speak to an attorney about your individual needs. But generally, yes. So what happens a lot of times is people have a trust, they put their home into the trust, and they still have a will, just in case there are any other assets that are not in the trust that need to be dealt with by surrogates court.
Okay, thank you. Miss Jones is asking, if my mother doesn't assign an executor for the estate, we have to go to probate or surrogate court.
I'm sorry. So I have been conflating a lot of terms because I was talking too fast. So, surrogates court is the name of the New York State court that we go to. In a lot of other jurisdictions, they use probate court or orphans court. And so a lot of people tend to just call it going to probate, but technically it is called surrogates court. And then there are special departments within surrogates court. So if you have a will, then you're going to the probate department. If you don't have a will, then you're going to the administration department. And if, let's see, your mother doesn't assign an executor, that sounds like she doesn't have a will. And in that case, then you are looking to do an administration. It could also, if you're asking like what happens if there's a, like let's say the assigned executor passed away in the will, hopefully there's a successor executor, but I have seen situations where, you know, all of our friends are the same age, and if we all pass away at the same time, it's kind of a problem. There could be what's called, I believe, like an administrator CTA, which is like the next best person. Like, you know, both executors have passed away, or both nominated executors have passed away, and now we need someone else, or perhaps one of the executors is very old and is unable to do all of this legwork. And so they are like, I pick someone else, I'm tapping out. Someone else could come in, but they usually have to show some sort of proximity to the decedent.
Thank you. This one is a question from Sandra. How does an estate have to be structured in order for the beneficiaries, inheritors, to not have to repeat the process upon their own death?
That's a loaded question. And I would say it probably depends. It's like everyone's situation is highly unique, right? Like no one has the same assets. And so I think one thing that I would say is to kind of, you know, prevent this is take the example that I was giving earlier, where my mom has 2 kids. She wants to give to me and my brother equally. I would say in that situation, do not give me and my brother the house, like if you can avoid it. If anything, try to give one child like the bank accounts and the jewelry or whatever to make up to get to the cost of the house, or as close as possible. Because if my mom were to give to me and my brother, she's created heirs property right there. And then we have, if, you know, upon her passing, me and my brother decide that we don't want to be nice to each other anymore, we have a fight and we have a problem that we are all seeing in legal services every day, between all these family squabbles. So to the best extent possible, like, or even like, you know, demand that the property be sold and like just the money be split. Um, if you're trying to create some sort of structure, if you have that many assets, then you should probably be talking to a private attorney and setting up a trust. That's, you know, a fancy way of doing it. I'm not as familiar with how to structure that. I hope that answered your question.
If it doesn't answer the question, please just ask a follow-up question coming on. Francesca is saying, thank you for the information. Her situation is elaborate. Is there a way that I can speak with someone one-on-one? It's too far to explain here in the chat. Yes, and as you can see, Lori put up our contact information. So there is definitely a way to speak to us one-on-one. I think we don't have Casey's email up there, but Casey, if you can give your email, then we can have that as well, if you want to speak with Casey.
So I don't give out my legal aid email. So I have a hotline, and so I can drop that information.
Yes, the hotline, please. And then for Susan just says, thank you, Susan, for listening. Stacy says, thank you for the valuable information. Thanks, Stacy. And then Sylvia, the reason why I asked about the recordings because it was very informative and I'm driving. I get it. I am not trying to be too funny with it. It's just that I'm not sure whether we're giving out the recording yet. We have to see if all of our agencies agree that the recording can be given out. So although it did seem like I was just trying to be funny, we'll see whether that goes out, but the materials will be handed out. That most definitely. Susan says, if my husband has me on the house as rights to survivorship, then will the house automatically go to me, or only if we have joint bank accounts?
No, so those are separate things, right? So if you are on the deed and you are joint tenants with rights of survivorship, the house goes to you. With the bank account, if you have a joint bank account, then that goes to you, right? But it has to be a joint bank account. And also, again, like not banks are funny. There's different kinds of bank accounts that you should probably, you know, check in your individual bank to see what exactly you have going on. Sometimes there are true joint bank accounts. Other times you might have situations where someone, so like, you know, my husband has an account and he adds me as someone who can access his account, and like I can write checks from it, but I'm not technically on the account. So the moment that he dies, like I'd have to go through surrogate's court unless I was also unless I was also a designated beneficiary for that account. So just like keep in mind that these are all separate entities. Like your deed is separate from your bank account, and you have to check on all of these things to make sure that all of your ducks are in a row.
Yes. And as Casey's explaining, if your name is on that deed, it goes to you without going to surrogate's court. That's the step that you would be avoiding. It automatically transfers. So your name is automatically there as the owner of the property. Donna is asking, who is responsible for paying property taxes on a home while it is in probate? And can I receive help as a current occupant, even though the title has not been transferred to me?
Technically, the person who's responsible is the financial representative, so the administrator or the executor. But I understand that can take a very long time. So again, lawyerly answer, it depends. If you, sorry, property taxes, Dion?
Yes, who's responsible for paying property taxes on a home while it is in probate? So, Casey's absolutely correct. It's the estate that's technically responsible for paying those property taxes. However, as Casey said, sometimes it takes a long time for that estate to be, for everything to be administrated, for the whole process to go through. So then what you may have to do as the occupant, you may have to pay those taxes, keep a record of it, and you give that to the estate. If you need help from the estate, then you can also petition the surrogate's court with the administrator to say that these taxes are outstanding. I need help to pay it, right? So you can do that petition as well. Susan was just saying she had stepped away. Sandy said, thanks. Sylvia says, do I need an attorney to create a trust?
Almost certainly. Yeah. And, again, I think you'll talk to a lot of attorneys and they will listen to your situation. And unless you are truly wealthy, a trust is not always the best solution.
Okay, and Emily, please, yes, a trust may not be the best solution. Again, you do speak with an attorney, right? If you have the ability to get a free consultation with an attorney, do that. So then that will kind of help you to see how it will be, how best to set up your estate. Emily on the panel is actually is making me aware that there's some questions and answer in the Q&A box, which I had missed. And Emily, please speak up whenever you want to. Please, the first one is please provide the website to check for lien scams and theft.
Yes, so I was able to provide an answer to that question, and I believe the website that you'll want to check is ACRIS, which is an acronym. It's ACRIS, and I did put this in the chat, but I linked to the New York City website where you can access ACRIS, and if you're interested in looking into whether your property has experienced deed theft, you should look up ACRIS and look up your property deed and make sure that no additional properties are associated with the address that you have and with the deed. If anything looks off, you'll want to follow up about that issue and reach out to the Department of Finance and try to make those corrections. And then there's another question that is asking you to talk about reverse mortgages. And I believe I'll defer to Casey for that one.
I think we'll defer to me a little bit.
Oh, I'm sorry. Go ahead.
No, that's no problem, Emily. Reverse mortgages is part 2. So if you all want to hear about reverse mortgages, come to 514 and you are going to hear everything about reverse mortgages, probably more than you'd like to know about reverse mortgages. But that keeps you interested and keeps you wanting to come for part 2. And then Francesca says, thank you. Sylvia, thank you. Marjorie, this is informative. I'm hoping everyone is learning because I'm learning as well. Malia says, how do we get the written information materials you referred to? So you should be able to get the deck. If you signed up, we should have your email and should be able to send you a copy of our the slides for this presentation. Here we go. Then, as Casey has said, if you look at the bottom, Casey had given the Legal Aid Societies to Benefits Helpline, 888-663-6880, the time Monday through Friday from 10 to 3 p.m. Donna said, thank you. And thank you again from Ramika. If I'm pronouncing your names wrong, please blame it on me. I apologize. Again, Valerie says thank you, and Beverly says thanks, very informative. And yes, Valerie, come to part two. We need you all to come to part two. I think it's going to be great. And tell people about it because it's a lot of information that we're giving. We know the tax lien sale is coming up. We know that everyone has property or has something that it's important for you all to know about how best to leave things for your loved ones, right? So please share the information. Please come out. It's very helpful. And you have experts, right? You've got, when do you get to speak to Legal Aid, to Brooklyn A? Come on, you have experts here, to Neighborhood Housing Services of Jamaica. They're amazing. And Senator Comrie's office, right?
I just wanted to add two things. Someone had asked a question earlier about deed theft and finding out if what's attached to your deed. One of the things that we recommend that every homeowner do is go to the Department of Finance's website and register. Register to be notified anytime there is any activity on your deed. So, if someone's, filing a lien, and people just arbitrarily file liens. You may go to sell your house and find out that someone or some company that you have never had any dealings with has filed a lien, and that can hold up, the sale of your property. So we advise go to the Department of Finance's website, register so that anytime there's any activity on your deed, you find out what that's about. Other thing I wanted to say is with respect to the list of properties that are up for the tax lien sale, is online. And don't think of it as being nosy. Think of it as trying to protect your friends and your neighbors. A few years ago, we did a workshop like this, and one of the people who attended the workshop said that when she found out about the tax lien sale, she went and looked at that list because she had a senior neighbor and she wasn't sure if that person was really capable of keeping up with things. And she found out that her neighbor's house was on the tax lien sale list. And she got in touch with her neighbor and they got some help and were able to get her removed from that list. So, be a watchdog, be a help to your neighbors and your friends. And as Dion said, share the information, please. Do we have any other questions?
I think there was just one other thing. If you notice, Casey shared in the chat to call the Legal Aid Society's Access to Benefits line, which I had mentioned about earlier. And then Susan is asking, where do you go to find out about the liens information? And I think Emily had answered that before, and you're going to go to ACRIS. So I don't know if I'm repeating, but I think that's it.
So ACRIS would be to see if there's deed theft, but I just put in the lien sale website link in the chat.
And when you go to ACRIS, there are a few ways to search. If you happen to know the block and lot number, you can search that way. Or you can search, but you can also search by the name of, if you happen to know whose name is on the deed. If it's yours, of course, you can search first and last name, and it'll bring up all the information. Any more questions, Dion?
I don't see any more. Emily or Casey, I don't think I miss any. Oh, where will the lien sale be held is the next question.
That is a great question, and candidly, I'm not sure. I don't know if it's a physical sale, but I do know that the dues, the debts, the dues, the arrears on these properties will be sold. So, Lori, Casey, or Dion, if you all have more information about where it's held or if it's something that occurs more virtually, I'm candidly not sure, but it is happening on May 20th, and so you'll want to act before then.
I think what happens is Before, we used to do it more physically. I think this year it will be virtual, but this is the first time since the pandemic that they're actually doing the lien sale. So I'm not 100% sure exactly how that will be done. It's in a
Ron,
new environment now.
right.
Thank you, Dion, for that information. That's really helpful.
You know, but as has been said, it's important to make certain that whatever arrangements you make to try to get off the lien sale list, that you do it by the 19th. The 20th is too late, so it's got to be done by the 19th.
Yes, absolutely. Thank you, Lori. That's right.
I think someone raised their hand, Dion.
Is someone's hand is up? I can't see it on mine. It might just be on yours, Lori.
Oh, well, I think it was a Miss Thompson.
Okay.
So, Miss Thompson, you can ask your question. Okay, you're gonna have to put it in the, I guess
In the
you can put it
chat.
in the chat, yeah.
Okay, I see on a Q&A, did we answer Kimberly's second question? What should be the language in the will relative to reverse mortgages? I live in the home and my mom's caretaker and and is her mom's caretaker, and there are four other siblings to whom there will be inheritance with the house, the sale of the house, but only after monies are paid back to the bank. I will call to speak one-on-one. My situation has many parts, too much to cover. Sorry, so it's not a question. They're going to call separately and then go through it. And Kimberly, I'm glad you're looking forward to reverse mortgages. We will come and bring our A game to that as always. I think that was it. Derek Davis apologizes for having to jump off, but of course he's still working as many of us are.
So again, so I guess we'll wrap up. I just want to thank everyone. As Dion says, please join us next week for part 2 of the workshop. This is, as they say about one's health, an ounce of prevention is worth a pound of cure. So it really is important for us to be aware of all of the issues that can affect, our homes, retaining our homes, being able to, transfer that wealth, down to other generations. So, do join us. You can reach out to all of our organizations on a number of other issues with respect to housing, legal housing matters. And, as you heard from Dion and Brooklyn Legal and Legal Aid, they also cover they provide a number of other services that are not necessarily housing related, but certainly are legal. So thank you all for joining us. I believe this was very helpful based on your comments. And stay tuned. If you've joined us today, you will continue to receive notification of workshops and seminars that we're going to be holding. Thank you, everyone, and have a great evening.